Hi, everyone. This is attorney Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Last Week Tonight Live, where we are live answering your questions and talking about your comments. It's all about you guys, the viewers, on this episode. So thank you for being here, and happy holidays to everyone. Happy Thanksgiving and belated Thanksgiving. I was a little bit I was home last week, and then I got a little bit under the weather. So, but now I'm finally feeling better. So I thought, okay, I'm feeling better. There's no court, so I got to do a live and speak to everyone. So let's see what we have here in the chat. Let me jump into the chat right away. We have a comment here from Come Along with Uncle Joe says almost time. And Jonathan says, my guy is the law doctor. Okay, awesome. Awesome. Hi. Thank you for being here. Thank you. So yeah, if you have any questions, feel free to post them to the chat. And I'll be, updating and reading the live chat and answering your questions. And meanwhile, I guess maybe I'll start with the other chat, like the chat from 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 YouTube, just from our channel. I'll start answering those questions while we wait for the live questions to come in. So yeah, let's see. Oh, Preacher says, hello, glad you are doing well. Oh, thank you. Hi, how are you? Yeah, everything is good. Just a little bit of us like sniffles and a cold. I guess it's going around now, but now I feel like it's going away. So I'm pretty much almost to 100%. I'm going to start doing things again, because I was pretty active. I was trying to get up every morning and go to the gym, do a little workout, do a little like light weights or some Stairmaster or something like that. And then ever since I had this, I didn't go. So now I feel a little bit like, like I gotta get out there, do something. I guess you see physical activity is important. So I could empathize with people who are injured that can't do things. It's terrible. And Nassau Boy, here's a question. Nassau Boy 68 says, hello, attorney. How long after the deposition does it take from there, from the other side? I don't know what this means, from the other side. Maybe he means how long does it take after the deposition? Does it take to hear? Oh, to hear from the other side. Oh, okay, I see what he's saying. To hear from the other side. Yeah, so basically, you don't really hear from the other side after a deposition. The way it works is, you do your deposition and they ask you questions, and then your lawyer will tell you how you did, like whether you did a good job or, if you didn't do a good job, maybe your lawyer will take you outside during the deposition, hopefully, because you don't want to do a terrible deposition, right? And then the lawyer will be like, well, let me you want to hear what happened? You sucked, you know like that. So you want the lawyer to be your guide and to make you do the best you can possibly do. So ideally, if you're not answering the question correctly, or if you're saying something that's bad, the lawyer will say, you know what, let's take a break, and then in the break take you out into the hallway and tell you, hey, da 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 da, this is what you have to fix, and then you go back in and you fix it. Or alternatively, if it's a Zoom deposition and you take a break, and then the lawyer could like call you during the break and explain it. So something like that. But yeah, to hear from the other side in terms of a settlement, it could be, there's no real bright line rule, right? It could be during the deposition, it could be a week later, it could be a few months later. There's no real like bright line rule about that. So there's nothing like that. Okay, and then Stukits Brothers say, in regard to medical bills, do you provide the health insurance company bills, such as Blue Cross, or do you provide each medical facility's bill? So in regard to medical bills, I mean, medical bills usually, if you're suing for the medical bills, like if the medical bills were not paid and you're trying to, that's part of your damages package, then you should provide the bills, or you should provide authorizations for the other side to get the bills. Yeah, I would do both. I would do the health insurance company, or each medical facility, whoever it is, either way is fine, whoever it is. I don't really do too much with medical bills because I'm mostly doing the personal injury part of it. And in New York, we don't have a rule. Like in some states, they have this rule where if medical bills, like triple medical bills is how much you get. these formulas. We don't really do that in New York, so it's more like the human damages. Now, of course, if someone's going to have future medical costs, that's a little bit different, right? Because if someone, let's say, has a need for a spinal fusion, okay, and they've had one spinal fusion, but then they have the need for a second, the need for a third. Or what you're going to have there is you can have an expert talk about future medical costs that are inevitable, and those costs could include things like, home health aid, future fusion. One fusion could be 100,000, right? There could be physical therapy visits, prescription drugs that you're going to need, costs of other surgeries, costs of other orthopedic visits, and then all of that could be like into the millions. That's different. That I would just do based on a medical expert, like a doctor saying that these things are needed, and then also an economist talking about what the costs are for all these things going forward into the future. So that's usually how I would do it. Okay. Yeah, so let's see what other questions we have in our channel here. Let's see if I can fix that. The camera's a little bit crooked, so no, it's okay. Okay. Let me see what we have here. Here's some questions in our channel. These are just some questions. Here's a question from Ace1313. It was 2 hours ago. He says, do you deal with workman's comp cases? I have some questions about my case. If you do deal with these cases, can I speak to somebody in your staff about my case? Thank you. Yeah, I mean, we do deal with workers' comp to some extent. We don't do the straight workers' comp because what we do is we work with partners, and those partners handle the straight workers' comp, meaning, let's say I'm at work, right, and I'm lifting up a box and I just feel pain in my back. That's a straight workers' comp. No one I could sue, right? I'm just lifting a box and I felt pain, but I have a workers' comp, meaning a work injury. So that's usually the way those are handled is you get paid for your lost wages, and you get paid for your medical treatment, your medical bills. I mean, not you, that providers get paid, whoever you go to. So that's usually how that works. And we do, interact with that, but we're not like workers' comp specialists. In New York, it's an administrative system. So it's all done by an administrative judge along with, so it's all administrative. There's no jury, there's no real trial. They call it a trial, but it's very, very simple system. So yeah, so that but we're knowledgeable. So if you wanted to speak with us, you could just text me 347-566-9595. I'm happy to talk about like workers' comp or refer you to the right person. If I don't know what you need exactly, I could refer you. But yeah, absolutely. Okay, let's see what other questions we have here. Let's see what other questions. A lot of questions here. Really, they're not questions. They're just like comments. People are upset about the delays. Like somebody saying, I got rear-ended in 2021. My case is still going on. I completed my treatment and therapy, MRI. I'm basically done, but the trial's not until 2025. And I find that's not necessary at all. And yeah, I mean, it's true because, right, I could certify a case as being ready for trial right now. I could say to the judge, hey, we finished all discovery, depositions, papers, we're ready to go to trial. But like say I'm in the Bronx, they're not going to give me a trial tomorrow, right? They're not even going to give me a trial maybe in all of 2024. They might give me the trial in 2025. And that's just because they have a lot of cases. It's just just the system. It's the city of New York. They have a lot of cases, and you're just going to wait because other people are ahead of you in line. So it's not really fair, but there's not really too much we could do about it unless until the courts kind of fix that issue. So yeah. see what other questions we have here. Here's a question we got about 14 hours ago from a Victor Valenzuela. And he says, it's been 4 years since my workers' comp, multiple injuries accident. I fell from a 2-story ladder onto concrete. Yeah, I'm sorry to hear that. That's terrible. And he said that his lawyer doesn't call him, follow up with him, doesn't return his calls or even respond, but he keeps the lawyer updated. And his personal doctor told him his body's not making red blood cells. The doctors can't do surgery on the C6, C7, and there's torn rotator cuffs, and there's gliosis from a previous trauma to the middle right frontal lobe. So it sounds like a brain injury. And he told his attorney about it, and the attorney just said, really? And they just keep going to his appointments. So it sounds like the attorney just wants to settle and he doesn't know what he can do. So yeah, I mean, just, I don't know what city that's in, or I would have to get a little bit more information to guide you, but I would say that doesn't sound like very good in terms of the attorney should be familiar with your medical care and should be able to guide you a little bit better and send you to the right specialist, especially for the traumatic brain injury as well as the C67 surgery. The attorney should be a little bit more involved in that. That's kind of an important thing. You don't want the attorney just to say, really, that's not good. So yeah, text me 347-566-9595. I'm happy to help with that. Whatever you need. If it's here in New York, I could help you maybe myself. If it's somewhere else, I could find the right person for you. And then Terry Nash says that her spouse was hit by a company van and his legs snapped off from under the knee. Oh my God, that's terrible. That's horrible, horrific accidents. And he's saying that the other leg was also broken. He's always in pain. The hip is not in line as before. He needed a hip surgery. And he isn't the same man that she married. And now he can't walk but a few steps. And she wants to ask, don't they have a file that she can do, because he wasn't this way when we met. So now she's got to bring like bags in from the car when we go to the store. He can't do that anymore. He can't even walk inside a store to shop. It's too much for him. No beach for him, no dancing for her, no trips. So she's basically saying she wants to do all these things, and what can she do? What kind of claim can she get? So that's known as a loss of consortium claim, right? When the husband or wife of the injured party and all of their losses. And there are lawyers that actually specialize in those kinds of claims and how to build that kind of claim up correctly. The old school philosophy was, oh, you don't really want to bring that kind of case because, it might not, the jury could say, oh, you weren't even heard and you said for better or for worse, and, it just happened to be worse. So kind of like, too bad, so sad, and you shouldn't get anything. But that's really old school. There are ways to present that kind of case and get a very large jury verdict. One of the ways is to say that this is an injury to the marriage, right? Not just an injury to one person, but an injury to the institution, to marriage. And you talk about the love, we talk about the things that they used to do, the things that you still want to do in the future, and how it's been affected. So that loss of consortium claim could really be a big claim. In fact, I've seen some lawyers do it where like the verdict for the personal injury was, let's say, pretty high, like 8 million, right? But the verdict for the loss of consortium was also significant, like 3 or 4 million. So it could be a big case. Yeah, the same thing I would say, just text me. I'm happy to give you a consultation. Okay, let's see what else we have here. I think we have some live questions. Oh, Leonardo says hi. Hi, how are you? Okay, that's one of our clients. I'm texting, always texting. Text text master. And then Bruce says, great content. Thank you so much. And Nikemia says, attorney, what happens when the insurance company lawyers keep extending discovery because of case overload from insurance companies? Well, they can't extend discovery just because of case overload. So what they could do is they could extend discovery if there's a reason to extend, right? If they have like a legitimate reason, and then you have to have a short leash with them, right? And be tough. And then if they extend a little bit, okay, fine. Give them like one courtesy. If they try to extend again, go to the judge and say, look, you can't. There's no reason to extend. We're ready to go for depositions. We're ready to give you our documents, give me your documents. And so I would just try to shut that down as much as you can. And then let's see what other questions we have. Wayne says, question for you. Do you let your clients know when the insurance company offers their first offer, or just when the offer seems somewhat fair? I think I would let them know like all the offers, even if it's low, but I also give them like my recommendation. So if I have a case and I'm going for like a big number, let's say I'm going for a result like $1 million, and I get an offer of like 5,000. I mean, I could let them know, hey, there's something that happened just out of like communication, but I'll say, look, don't even take it seriously. So because you don't want to, what do you? It's just a formality. Okay. And then Ricey says, Mr. Attorney Frekhtman, the best. Thank you so much. And then Truth Seeker says, quick question. Once again, thank you for that wonderful video you made. If you get injured on a commercial van, not an accident, but say you get injured to the heat exhaustion due to the commercial vehicle. He's talking the commercial vehicle, and he says, giving you a non-operating air conditioning vehicle. Are you entitled to the vehicle policy? So a non-operating vehicle. I mean, it could be, depending on the injury. If the injury is really severe, it could be. So it's a commercial vehicle, and it's a non-operating air-conditioned vehicle. So basically, the vehicle doesn't work, right? It's non-operating. If you have a serious injury because of that, in fact, I think I might have done a video about that. I don't know if it's been uploaded yet, but there was a case where I believe that happened in a train where I think it was a train conductor was in a train, and something like that happened where the air conditioner was broken, and so it got so hot in the train that the poor guy suffered like brain damage or really serious injuries, and then they sued under the FELA, which is a federal statute for railroad workers, and I think they won. It was like a big verdict, like 15 million. I don't know if that video was published yet, but if not, probably it'll come out like next week or the week after. I did a video about that, so yeah, you could recover for that. Okay, and then Nikemia also says, when can you file summary judgment in a rear end crash after deposition? So yeah, summary judgment you can file even before deposition. Summary judgment you just file when you have enough evidence to show that there's no issue of fact that you even need to go to a jury, right? Because remember, a jury is a fact finder. So it's like a group of people, usually 8 people, six in New York with 2 alternates. Some states it's more, it's 12 people, and their authority or their providence is the facts, right? What happened? They have the final say about all factual questions, right? So facts are, for example, I say, hey, I got rear-ended. Now you say, I didn't rear-end him. He ran a red light and hit me. That's a factual issue. Who's telling the truth? Credibility. So that's all the jury's purview. The jury decides that. But if you have something like where, let's say I'm stopped at a red light, this other guy came and he hit me in the rear, there's no question for a jury to decide because it's indisputed, right? The police, we have video, we have photos, we have damage to the cars. There's no question, right? So you just file a summary judgment motion, you get a judgment as a matter of law. There's no question for this jury to answer. So that could be on liability. Sometimes you can get summary judgment on damages as well. In fact, in New York, you have to have a serious injury in order to sue in a car crash. So if you don't have a serious injury, you get dismissed on summary judgment. Or you could file an affirmative motion to say, look, I meet one of the categories. Now the judge says, hey, you meet one of the 9 categories. So if you meet a category, we'll now just do a trial and see how much it's worth. There's no reason to have to prove that it's a serious injury at trial because you've already proven it through summary judgment. So there's two ways to do it, and you could do it on serious injuries, you can do it on liability. Usually summary judgment deals with liability, usually, but it could be both sides. Okay. And then Leonardo says, this guy's lucky to get his trial for 2025. Mine was beginning 2020 and far from trial. Yeah, well, yeah, it takes time, unfortunately, but we just try to do it as quickly as possible. And let's see, Gary says, hey, yeah, Mr. F, love your videos and live feeds. Thank you so much. Thank you. Okay. Let us know what you want to see. Yeah, feel free to drop us a comment right now, or let us know what topic you want to see for a future video. That's what we're here for. We're here to help. Our goal is helping serious injury victims and families, helping you, so we're happy to help. Thank you for watching. And Truth Seeker says, thank you. You're awesome. Thank you. Yeah, absolutely. Thank you. And Derek says, I'm back. Can you go over compensable injuries? Oh, right. Derek, that's the person I believe from, yeah, okay, that's right. We're going to do a video together. That's the client who was in a workers' comp workers' comp case. And we're going to do a video maybe next week. Probably we'll do it on Zoom. We'll record it, and then we can post it, or we could, see if it needs to be like edited or anything. I usually don't this is live, but some of the ones that are recorded, I don't really edit them. I just kind of do them and just post them. But, we'll see. We could do that. I think he sent me a few topics, right? So I'll go over the outline and I'll add a few, and then we'll probably do it on a Zoom and just record it and then post it to YouTube. Yeah, that'll be fun. That'll be fun. Like, you get the client's perspective, somebody who's actually, in a case from the client's vantage point, right? And then you also get the lawyer's perspective. So it's interesting. Let's see. And Nikemia says, how long after a deposition should an attorney put the lawsuit on the trial calendar? So, it's hard to say because, if it's the final deposition of the defendant and that's all done, then you can do it right away. You could do it maybe even days later. But if it's like the plaintiff's deposition and you still need to depose a bunch of defendants, you might need to depose like 2 or 3 defendants. So then I would say wait until all depositions are done. And once all depositions are done, then certify it as trial ready. Because you don't want to certify it prematurely, because then what could happen is the defendants will say, I'm going to file a motion to strike your case from the trial calendar, strike the note of issue, because you put it on the trial calendar prematurely. All discovery is not really done. I still get to do my DME. You didn't depose this defendant. Or they could say, you know what, fine, leave it on the calendar, but now you can't, but now you haven't deposed one of the defendants. So now you have to just examine them at trial without the benefit of a deposition, which is not advantageous to the plaintiff's attorney, right? Because like for me to prepare for trial, I like to read the deposition transcripts. I like to, pull out all the issues, and then you can cross-examine them. And if they say something different from what's in the deposition, you can impeach them. So you could say, wait a minute, on page 293, line 37, you said this, but today in court you're saying that. Which one is it? You can impeach them, right? That's a big thing in trial. But if you don't even have a deposition, you never depose anybody, now it's kind of more difficult. You have no impeachment evidence, right? You have no ammunition for impeachment. So it's weaker. So, so it just depends. But I would say usually after all the depositions are done, it's not too much longer to put it on the calendar. Okay. And then Ty says, I'm dealing with a personal injury case as we speak. The defense lawyer will meet to see their doctors. Mediation is in March. Trial date is set for May. It's a TBI case. Okay, that's good. Yeah, TBI case should be a serious case as long as you have the neuroradiology, like all the scans, like the diffusion tensor imaging, 3T MRI. You have the neurologist testify. Those could be big cases. So, and I guess the defense lawyer wants the client to see their doctors. Yeah, that's the DME, the defense medical. They call it the IME, the independent medical, but it's not really independent because it's the defendant's doctors. They just call it independent to sound fair when they're not fair. That's silly, but it is what it is. But yeah, you got to do that. It's one of the steps in the process. You do have to do that. Okay. And then Gary Piat says, I'm the one with the trip and fall at the truck stop. The rotator cuff repair failed. The bicep tendinosis failed. Had to have a total reverse shoulder replacement surgery. Oh, I'm sorry. Yeah, that's serious. That's very serious. Shoulder replacement. That's super serious. Yeah, that could be a big case. Yeah, I think you might have texted me already. I'll take a look. But yeah, feel free. Just remind me, because I've been a little bit, like I said, I was a little bit sick. Just getting better, and I was also a little bit busy before that and with the holidays. So if I didn't text you back or if I didn't respond to something, just shoot me a little ping, ping me at 347-566-9595. And I'm happy to jump on a call. I'm free. I should be free tomorrow. Tomorrow I have this tomorrow I'm going to Manhattan and we have a trial lawyers college group. We have a New York City working group, and we meet and we talk about cases, and we practice like voir dire, picking a jury, giving opening statements, doing direct examinations, cross-examination. So I'm going to be there working with them for part of the day. But then the rest of the time should be free, so I could probably do a few calls tomorrow or next week. Also looks pretty open. Things are slowing down a bit. So holidays are coming. December's usually things are slowing down, so that's good. So yeah, feel free to text me if you need any kind of advice or consultation about that. That sounds like a serious case. And then Wayne says, would love a video where you show exactly how each offer and counter offers change in the dollar amounts as time went on in a case that settles without a lawsuit. Without a lawsuit. Yeah, I mean, I've done videos on that, but probably with a lawsuit. Like without a lawsuit, see, the problem is they don't really pay without a lawsuit. So like, say, for example, if I was trying to settle a case without a lawsuit, pre-litigation, right? And let's say it's a car crash case and I wanted to do it. So, and it's, let's say, I don't know, it's a 100,000 policy. So I could say, give me 100,000. They'll say, no, we'll give you 10. And then I'll say, you know what? Okay, 10 is ridiculous. I'm reasonable. I'll be in good faith. It doesn't have to be 100, but give me something like 80. And then say, okay, 15, and then wherever you get to, maybe you get to like 25, 30. That's probably a good settlement without a lawsuit. But with a lawsuit, I've seen cases where in the beginning they tell me, hey, you know what, this case is worth 15,000. That's all we're ever going to pay. But I file a lawsuit, I move the case along. During the pendency of the lawsuit, like while the lawsuit's pending, the client may need to do a surgery, like a fusion, something else. I have cases settled for like 975,000, almost $1 million. They're trying to get rid of the case for 15 before the lawsuit is filed. So the difference could be huge, huge, like $1 million difference. It's crazy. So yeah, but I think there's some videos about that. It's a good topic. And Gary says that they're still in the discovery stage and will enter mediation once the surgeon releases him in 3 to 6 months. Okay, yeah, that's good. Okay. And then Lee says, how do you know if your attorney is doing a bad job? What's one red flag? Yeah, that's a good topic. I've kind of done some videos about that. Maybe I'll do a video where I kind of outline all the issues and I try to do a deep dive into that. But I would say like one big red flag is communication, right? You definitely want open stream of communication to be able to like for example, I give my number out. You guys aren't even my clients, right? I mean, and I'm giving you my cell phone number, right? 347-566-9595. You can text me. So if you don't have that kind of access, like unfettered access to your attorney, but this is an attorney that's actually representing you, that's not a good sign. That's a red flag, because you want, to be able to tell your attorney what's happening, but you also want guidance from your attorney. And a lot of these attorneys are busy. They're just saying, I'm too busy, I can't call you. But, they have to make time. Like, I'm busy too. I'm doing a lot of things. I'm doing prepping for trials, handling cases, doing some marketing stuff, doing, a bunch of different stuff, writing motions, writing pleadings. But I find the time, maybe like, even if it's an hour a day, from 4 to 5 or from 3 to 4, and just call clients in that hour, as many clients as they can. Maybe each call is like 20 minutes, and just make yourself available. Or if you're not going to call, then text or email or whatever, but you want to have that communication. That's important. That's one big red flag. If they're not communicating with you, if they're not responding to you, if they're not keeping you updated. Another huge red flag is just whether they are a trial lawyer, right? Whether they have that requisite experience. Because, like, for example, if it was medical if he's not a surgeon, right? If he's never been in a surgery, if he's never been in an operating room, if he doesn't know how to take out your gallbladder, well, guess what? If you need your gallbladder taken out, you're not going to go to that guy because he's never taken out a gallbladder. Maybe he's scared of blood. He's like, ah! So it's the same thing. A lot of these guys have never been inside a courthouse, or if they have, they've just argued motions or they've gone to preliminary conferences. I mean, like my neighbor who's not even a lawyer, he could go to a preliminary conference. You know what a preliminary conference is? You show up and they're like, let's do depositions. What's a good date for depositions, counselor? Okay, I like the date March 14th of 2024. Okay, March 14th. That's a preliminary conference, right? You just pick dates and they put the dates on the calendar. Anybody can do it, right? You don't have to be a lawyer to do that. But like a trial, you do, right? You have to know how to get evidence in. You have to be able to be persuasive, be able to speak to the juries in a certain way. It's a whole thing, just like a surgeon, right? So yeah, so that's a big thing. Make sure that the person handling it is a trial lawyer, or if they're not a trial lawyer, that they have a trial lawyer, and that the trial lawyer who's going to try your case is going to be intimately familiar with you, because that trial lawyer should know you and should be able to tell your human story if it's a life-changing forever injury. Because if that trial lawyer can't tell your human story, then what's the case then? The case is all medical bills. No, that's terrible. Or just saying I had a fusion at L5S1, what's that worth? But no, you have to be able to say I had a fusion at L5S1, and this is who I am. These are my passions. I love my kids. Now I can't lift up my son anymore, or how it's affected you. You have to do a deep dive. You have to have photo albums and pictures, and it's a whole big thing, So so I would say those are like the big red flags for me. But yeah, that's a good question. I'll probably do a video all about that. Okay, and then Lee says I have a workers' compensation case. I had a fusion in my low back, and they told me I might need another surgery. I had 2 already. How much do you think my case is worth? So yeah, again, is it straight workers' comp, meaning just like without any third-party personal injury lawsuit? If it's straight workers' comp, I could probably put you in touch with a workers' comp lawyer in your area, like a local expert, and they could probably tell you. I couldn't tell you, depending on where you are. But if it's a personal injury case, like a car crash, trip and fall, or a work accident, but where you could sue a third-party lawsuit, then I would say that should be worth a lot. With low back surgery, that could be anywhere from like 300,000-500,000, even into the millions. It all depends on all these factors, right? That we kind of talked about, like the human story, the overall impact to your life, future medical costs, economics, lost wages. So I'm happy to just text me 347-566-9595. And then here's a question. Hey lawyer, I broke my ankle on a mat construction job site, injured my lower back, both shoulders. The GC is ready to settle. How much longer do I have to wait? So broke my ankle on a mat in the construction job site. So that's a good case. If it's a construction accident, if it happened here in New York, that's a really good case. And a broken ankle could be worth a lot. I mean, I'd have to look at the medical records. Was it broken ankle with surgery, without surgery? But yeah, that could be worth a lot. And I don't know. Also, if it's in New York, there's the labor law, like 240, 241. But how long you would have to wait for them to settle? Depends on what stage it's in. So if it's in, let's say depositions have been done and you're on the trial calendar, probably just maybe that additional wait from the trial calendar to trial. If it's like, let's say in Manhattan, it might probably be about a year. But if they settle early, they can settle at any time, right? If they're ready to settle, hey, they can settle today. So then you don't have to wait it off. So it just depends on all those like circumstances. There's no one answer for all cases. It's just very case specific, like what stage is your case in. It's kind of like, imagine a case is like a train, right? And a train goes from station A to station Z. So it's just like, where is your train now? If your train is at station Z, like say all the way over here, right? Then it's almost going to settle. But if your train is just starting and it's over here, it's a station like A or B or C, it's just starting, well, then it's going to take longer, right? It's just like, so I can't really tell you just based on that. But, I'm happy to just text me 347-566-9595. I'm happy to jump on a call help you out. But that sounds like a good case. And Nikemia says most law firms have case managers, and it's impossible to speak to an attorney. Oh yeah. Well, I mean, yeah, we have case managers too, but a case manager shouldn't be like a barrier between the client and the attorney. The case manager should just make the attorney's job easier. Like, for example, okay, you sign up a new case, and the case manager is going to send that letter to the insurance company saying, please be advised that we represent John Smith. Okay, because an attorney, for me to sit there and type, please be advised, or whatever, it doesn't make sense, right? You have to have an attorney who's doing like high level work, or trial work should be doing that high level work, right? Because time is only, it's finite, right? You only have so much time. You don't want to waste your time on those kind of tasks. So it's good to have assistants, case managers. Also, like if I need, hey, the client to go to a doctor, rather than me calling the doctor, making an appointment with the doctor, getting the insurance information, the case manager can do that. But if the client has some kind of question about like, okay, they need surgery, should they go to do the surgery, or they have some kind of question, or they have some kind of issue, that's different, right? Or if I'm trying to build up the story for trial, that's something an attorney has to do, right? Because you don't want the case manager building up the story, but then the story is in the heart of the case manager, but the case manager is not going to try the case in front of the jury. It's going to be the attorney, right? So the attorney has to do that personally. So it's just different tasks for different people, different strokes for different folks. It's just different. It can't be. That's not good if the case manager is doing everything, and then if the attorney's not able to speak or not willing to speak to the client. Okay, and then Joy says, love your videos. They have been so helpful. Thank you. Thank you. Thank you for watching. Yeah, absolutely. And then Lost in Awareness says, can you speak on eroding policies because it's important and lawyers don't explain it? Eroding policies. Yeah, I think that just means that I could do a video about that. I probably have to research it a little bit and outline it. But eroding policies just means that like the policy gets eroded or gets decreased because certain things already get paid out. So let's say, for example, you had a policy and somebody, for whatever reason, a portion of it was for property damage and that got paid out. Well, now instead of 300, you only have like 295 because 5,000 got paid out of property damage. So it kind of goes down. Or sometimes if you have multiple claimants and somebody gets paid, then there's less for everyone else and you have to split what's left. So, but I don't really deal too much. I don't see too much of that because the way it is in New York is we have a policy. Let's say it's $1 million over $3 million. Well, it means it's $1 million for one person. That's the most any one person can get. And the 3 million, the second number, well, that's for the whole crash, right? So even if you had 100 people in that crash, the most that they could get is 3 million among all 100 of them. So policies don't really erode that often here. I don't really deal with that too often, but I'm happy to like research that and outline it and do a video about it. I think that's a good topic, eroding policies. And then Derek says, he's been in workers' comp for 10 years. Wow, yeah. Now I'm looking forward to that video. I'm going to outline that and we'll pick a time next week. We'll do that. That'll be good. We'll talk about all that. And Gatry says, if you have more than one diagnosis, can you get paid for each? Yeah, of course. I mean, diagnosis is just basically the doctor telling you what your injury is. So if you have, let's say, a broken arm and a broken leg, you get paid for both. Of course. Why would you only get paid for one? Of course. Yeah, absolutely. And then Miscellaneous says, yes, with surgery, and it is in New York City, MTA job. Oh, that was the gentleman or the lady. That was the person about the broken ankle. Oh, the construction site case. Yeah. Text me about that. I'm happy to chat with you about that or give you a consultation. That sounds like a good case. Yeah, I just did a video this morning actually about another construction accident case, and I think the verdict was like 6.2 million. Those cases can be really big because what they include is pain and suffering, future and past, but also future medical expenses. Like in that case, the 6 million one, there was 2 million in pain and suffering, but there was like 4 million just in future medical expenses because the person would need future fusion, future knee replacement, home health aides, physical therapy. There were like a few different categories, and then there were some other things like lost wages. Lost wages actually in that case weren't, I mean, they were something, they were like 250,000, but they weren't huge. But altogether it was like over 6 million. And actually the appellate division, because I did videos before where I talked about verdicts, and a lot of the times I'll say, hey, somebody got $100 million verdict, but the appellate division just cut it down and said, no, take 10 million, right? This case, they actually reviewed it and they said it's sustained, right? The whole verdict got sustained because the injuries were sufficient. All 6.2 million was sustained. So that's pretty significant. And then Kevin says, do attorneys negotiate medical bills down? If so, can you give an example? Yeah, I mean, medical bills, like for example, if you have a medical bill and the case settles, yeah, I'll give you an example. I just did it. Like the case I settled for 3.5 million, right, in the Bronx, it was a slip and fall. So the guy had a medical bill for like $80,000 because he's been treating a lot. He had fusion, he had this, he had that. And so, yeah, we just called. It wasn't me, it was my one of the case managers, actually, was my COO, my chief operating officer of my firm. She called the office. She spoke to the head person there, and instead of paying 80,000, we paid like 40 or whatever it was, like much less. Still had to pay something, but they negotiated down, and because look, at the end of the day, 3.5 million, a third goes to the attorney, right? So here, let me get I'm not good at math. I'll get my calculator. 3.5, you take a third, that's like 1.15. So 3.5 minus 1.15. So the client gets 2.3, let's say without any liens, without any, debts. This client had some funding, some other stuff, but let's say just it would be 2.35 million. So if you could save another 50,000, so, it's significant. And it's the difference between getting like, and not every case settles for 3.5 million. Some cases settle for 100,000. Then it makes even more of a difference, right? So yeah, if you save somebody like 50,000, you just negotiate it down. It's pretty easy. You just call them up and you just basically just ask them to to pay them less. There's no real science to it. You just say 80,000. I mean, we understand you guys did a. On the one hand, like it's a letter of protection because like you signed it. It just means you're protecting their interest and they're treating your client for free. Right, because they can be billing like no fault, workers' comp, whatever, health insurance, but they're not. They're just treating him for free. But then when the case settles, well, now you have a pot of money in your escrow account, so now they want a piece of money, which they're entitled to. But there are certain ways to lower that. There are certain tricks you can use. So yeah, I would try to get that lowered down. And then Lost in Awareness says, I was asking about the eroding policy because I was told that it also covers defense lawyer fees. So it makes you question whether to file a lawsuit or not. Lawyer fees. I don't know. Yeah, I don't want to research that, but I'm not too familiar with that. How lawyer fees? No, lawyer fees are different. I mean, maybe if it's an eroding policy, if it covers the lawyer fees. But I mean, in my experience, like it's always good to file a lawsuit if you have a serious injury, because if you don't file a lawsuit, then they're just never going to give you any money. So even if it's an eroding policy, oh, I see what you're saying. So the lawyer fee. So for example, let's say somebody gets into a car crash, right? And it's a big policy, like $1 million, and you're going to sue the defendant, right? Like the company, let's say ABC Company rear-ended you at a red light. You're going to sue ABC Company. Now, ABC Company has XYZ Insurance Company, right? That insurance company is going to go and hire White Shoe Law Firm, BB&B, whatever, law firm to represent them. So BB&B is going to say, okay, well, we're going to bill the insurance company like $500 an hour, and over litigation, that $500 an hour might be like, 100 grand. So then the 100 grand is eroded off the policy. But I don't know. But then are you saying that the plaintiff is going to get less because of that? I don't believe so, because I think that that's between the policyholder and the insurance company. But I don't believe that the amount that they pay for third parties that are injured can be eroded by the defense costs. I've never heard of that, but I have to research that. It's interesting. I don't believe so. But it's always good to file a lawsuit anyway, because look, even if they erode a little bit, but you're still going to get a big amount, right? Because you're in litigation. Because you're in a power position. You're basically saying, look, pay me $1 million. If you're not going to pay me the $1 million, fine, I'll go to a jury, but I'm going to ask the jury for $3 million. So you're in the power position, right? You have the leverage. If you don't even have a lawsuit filed, why do they even have to talk to you at all? What do you have, a claim? Okay, you have a claim. Good luck. They could say, okay, I'll give you 10,000. You don't want it? Okay, then zero. And go pound stand. Then what are you going to do? You have no lawsuit. You can't go to a jury. No one else is going to make them pay. So whether it's eroding or not, I don't see how it matters. So I would say it's always good to file a lawsuit. It's always good to file a lawsuit. But yeah. So, but yeah, but I'm gonna look into that eroding policy. Maybe I'm not understanding it correctly because I haven't dealt with it too much. I've heard the term, I've heard about it, but I haven't really dealt with it myself. But then again, I'm not an insurance expert. I'm more of a personal injury lawyer. So, and so Lee says, can somebody comment me his number? Oh yeah, sure. I'll drop it here. You could text me. I'm happy to chat. 347-566-9595. Let me see. How about penalties and sanctions and how it helps your case? Penalties and sanctions, yeah, I usually don't ask for sanctions, only if a defendant is really, really doing something crazy or something like really willful and dishonest, then sometimes you can get sanctions. We don't get penalties too often either. The one type of serious penalty is punitive damages, which are meant to punish, but that has to be really egregious conduct, almost like where they know, hey, if we do this, it's going to injure and kill like people, but we don't care. We just want to make money, so let's do it anyway. If you can really show that, then yeah, you can get punitives. They're known as exemplary damages. But sanctions, usually they sanction you just for like, basically violating something. Like if they say, hey, you have to provide, let's say, I don't know, discovery, and you don't provide it. Well, the sanction is then your answer gets stricken, which means that you can't defend yourself anymore, right? Or if I don't provide it, they'll say your case is dismissed, which is the sanction, but that's the penalty. Now you don't have a case. That's a pretty serious penalty. So yeah, sometimes they'll say, okay, the penalty is pay like 5,000 or pay 1,000 or pay, whatever, 10,000. So it just depends on the conduct. And then Beach Bum says, so what if you posted something on social media that the insurance wants to use against you, but you have medical proof that you're hurt? Yeah, it depends on what it is. If you posted something on social media, I would say make it private, just so your friends could see it, not so that everybody could see it, right? Because you don't want to be like two-faced. You don't want to be like, basically, because when you're coming into court, right, what are you saying? You're saying that you have a life-changing, forever injury, you have a serious injury. So it goes to credibility. Is that true? Is that credible? If they have you on Facebook, like, I don't know, doing something like running or lifting something really heavy, and you testified under oath in your deposition, hey, you can't lift something that heavy, but they have you doing it, that's not good. Now your case value can go down significantly. I actually had a lady, this was many years ago, like 12 years ago, she had a nice case, she got hit by a car, she had a, I think some kind of back surgery, not like a fusion, but maybe like a discectomy, like a percutaneous discectomy. And so she, we thought her case was worth like, 500,000 or 700,000. And, right before trial, I see a video of her and she's in Costco and she's picking up those 5-gallon water tanks and she's putting them in her car and they have her on video. I'm like, wait a minute. So you're that hurt that you're picking up one after the other? And she didn't look hurt. She was picking them up like better than I could. She's picking them up, could have given the van. I'm like, oh no. And then we ended up settling the case, but it went for less instead of like 500. I think it went for 275. So yeah, it doesn't help. So having proof that you're hurt, of course, is good, but you don't want to have that out there. And it's easily avoidable, right? Just don't post it. Don't post it on like Facebook or Instagram or wherever, TikTok, whatever your platform of choice. Just don't post it there, because that's for the world to see. And they have investigators. They're very good at combing that and searching that, right? Because they're billion-dollar companies. So they're going to find it. Just make it like private so that only like your friends could see it. Then it's fine. Then they won't be able to see it. It's like a photo album, right? If I have a photo album, but it's in my drawer, only I can see it. But this is like a photo album for the whole world. You don't want that, if especially if it contradicts what you're saying. And then Scott Adams says, corporate shield for early settlement by non-suiting physician and putting physician group and their malpractice insurance on the hook without the penalty of reporting to NPDB. Interesting. Not sure what that is. Maybe that's a corporate shield. Non-suiting physician. So maybe that's some kind of a medical malpractice case, I guess. Yeah, we do some medical malpractice cases. We do that, yeah. And then iGod Mode says, my lawyer spoke to the opposing lawyer and told him 12 million, and I'm worried he's doing the rule of 3 that you were speaking of. My question is, by him saying 12 million, are we held to that now? I mean, yeah, probably they're not going to give you more than 12 million if you already asked for 12 million, right? So 12 million is kind of like what he asked for. So yeah, I mean, probably you're held. I mean, you could always go up, but the insurance company might not negotiate with you because they might say, well, wait a minute, you said 12 million, now you're saying 15. So if I give you an offer against 15, tomorrow you'll come back and you'll say 20. And then after that, you'll say 25. Well, where are we going with this? You got to give me an actual number that's going to settle the case. And in a way, they're right? Because you can't just like keep going up. But that's why, like, what I like to do is not do that, not play that game, but just say, look, I reviewed the case. Here are all the medical records. Here's all the proof. And look, it's worth 12 million. Pay me 12 million within 30 days. If you don't, then, or pay me close, like in that range, I'll negotiate in good faith. But once those 30 days are expired, 12 million is off the table. And now the minimum I'll ever ask of a jury is going to be like 20 million or whatever number you feel it's worth. And I would do it that way. I think that's better. But if he's thinking about the rule of three, then, what is he? He's trying to get 4 million. So he's asking for 12 to try to get 4. People do that too. That's another negotiating. There's a lot of different negotiating techniques. Negotiation is like an art also. There's a lot of, that's hard to say, but there's a lot of techniques for that. And then Playboy Reaper. Defense only wants to strike down the case and drag out the deposition. Yeah, that's true. Unfortunately, the defendants want to, delay. They want to delay. That's very true. And then Beach Bum says, what if it's an old video that you did years ago and that you uploaded and have proof it's from a different date with a hotel receipt? Oh yeah, then it doesn't matter. Well, if it's before you got hurt, who cares, right? But actually, then you want it, right? Because then you're gonna use the video for your benefit. You're gonna say, look what I did. The Beach Bum, I was surfing. Look at me surfing this wave, and now I could never do that again because now I'm hurt, right? Or whatever it is, right? Whatever's in the video. I'm just guessing, But yeah, absolutely. Then it would be for your benefit, right? That's completely different. What I'm saying is you don't want a video of you, saying you're hurt and can't do things, but then they have you on video doing those things. But if it's before you got hurt, then, yeah, that's the whole point. Before I got hurt, I was whatever, surfer, ballerina, I was lifting weights, I was like playing rugby, whatever. And now I can't do that. So those are the things I love, fishing, I can't do that. I lost these things, right? That's my loss. That's different. That's actually good for you. That's a good thing to do. So I recommend doing that. That's one of the ways to prove the human damages. Yeah, so that's good. Okay, let's see. Opposing counsel keeps asking for discovery, but they were given everything already. Yeah, so have your lawyer deal with that. Just tell them, look, we gave you everything already. Let's move it along. And then Scott says, the corporate shield refers to cases in which the physician's medical corporation is named as a party in the lawsuit, and the doctor is either not originally named or dismissed prior to the settlement, specifically for the purpose of avoiding a report to the NPDB. Oh, I see. I think I see what he's saying. Right. Because he doesn't want to report that he committed malpractice. So it's just only his medical corporation is named. Yeah, that's interesting. Yeah, I have to I think I've heard of that also, but I'm not like an expert in it, but I've heard about, corporate shield. That sounds interesting. And then Li says, I injured at work doing repetitive work. I had 2 low back surgeries, one including a fusion, and it still hurts like I had no surgery, but I live in California. Okay, repetitive work, so it sounds like a workers' comp. Yeah, maybe I can get you somebody. Feel free to text me. I can get you somebody who does workers' comp, maybe for a second opinion. So Beach Bum says he posted a lot of old stuff, right? But yeah, that old stuff doesn't matter. If it's before you got hurt, it doesn't matter. Like I said, that's actually to your benefit. You say, look, before I was doing all this stuff, now I can't do it anymore. So I lost all that, right? So that's fine. Okay. All right. Yeah, let me know what other questions you guys have. But if not, maybe I'll call it a day. We're almost at the hour mark. Wow, time goes by. Time goes by when you're having fun. and talking about personal injury, helping people, and answering questions. Yeah, you guys asked a lot of good questions, very insightful questions. We talked a lot about a lot of fun topics. But yeah, feel free to text me anytime, 347-566-9595. Leave a comment on our YouTube. You could also let me know what other topics you want to hear about in the future. Like and subscribe to our channel. And I'm actually thinking about something new. You know, a lot of these other creators, they have almost like a little community where people could go. And in that community, you could have certain things like events or, you know, other videos or documents that you could share or chats. So maybe I'll try to create something like that. Let me know if you'd be interested in something like that. Maybe I could create a little community for my viewers, and then you guys could go there. And then instead, you could still text me, but you could also maybe ask questions there, and you know, be like a little community, like almost a private community. So maybe I could create something like that. I have to think about, like, you know, what features you'd want in a community like that. So think about that. Let me know, and then as I build it out, I would, you know, do it based on what you guys want, what the audience wants to see. So yeah. And then Ricey says, have you ever had a client with Wartenberger's syndrome? No, you know, I don't think I have, but I've also heard about that. That's a pretty serious syndrome. So maybe I could do a little research into that and talk about that. And then Beach Bum says, do they send private investigators to you after the denial of your claim, or do they keep them still after they think they have what they need? So yeah, usually they do it after your deposition, right? Because I mean, in New York, I don't know how they do it in other places, but what they like to do is first they want you to testify, right? It's almost like it's almost like a trap, right? So first they want you to testify, and they're going to ask you, what can't you do? And you're going to say, well, I can't, like, for example, that lady, I can't go to the store. I can't lift 5-gallon waters and put them in my car, or I can't lift grocery bags. And then they record you doing what you just said you can't do, like lifting the 5-gallon waters. So then you're a liar, right? So that's the way they usually do it. But I've seen them do it right after the deposition. I've also seen them do it later, like right before trial. Not right before trial, but like that month before trial, a few weeks before trial, because they could serve it at any time. So they serve that sub rosa, it's called, the surveillance video, but closer to the trial. I haven't seen them do it too much like in pre-lit. In fact, I've never seen them do it in pre-lit. If the case isn't in court, they usually don't do it. Okay. And then Derek says, you're awesome. How do you jump in and out of cases? Oh, yeah. Oh, thank you. I mean, like, I don't know, I just try to, you know, do my best. I don't really, when I'm actually working on a case, I don't really jump in and out. Like I'll just work on one case. Like when I know I have a trial and it's a final trial date, I'll just work on that case. I try to work like every day on that case. I mean, I'll have to do a little bit of work on other cases too, depositions or something, you know, client calls about another case. But I try to like really focus and just get ready, almost like getting ready for war, getting ready for battle, like get ready for that case. Yeah, and then Nikemia says, is an injury from an accident 35 years ago relevant today as a pre-existing injury? 35 years? No, I don't think so, unless, you know, you're still feeling that, depending on what it is, but 35 years, that's a long time. So I wouldn't say it's too relevant, you know. Oh, he means with the questions, jumping in and out. Oh yeah, well, I just do my best, you know. I have to jump around depending on what you guys, it's live, so whatever you guys are interested in. So I just do my best, but I probably could give you even more valuable information if I had more details, but it's hard in the chat, I know, to get details. Okay, let me run, but thank you so much for being here. I really am appreciative, and I'm grateful for this nice audience. Everybody's here listening, you know, interacting, writing comments. That's awesome. And we had, like, I think at one point 30, I think now we have 32 people. Before we had like 30 something people. It's great. Probably we had hundreds of people over the whole hour. So thank you so much. And we are here for you. Please like and subscribe to our channel. Yeah, think about that, like that community where you could go and think about like what you would want to see in that community. Because I want to maybe set that up, maybe see if I could do it before the end of the year. So something new for the next year. And yeah, and talk to you very soon. Have a great night, and happy holidays to everyone. And I will probably do another live next week, as well as some more videos coming your way. Okay, bye bye everyone.